Everybody's not on there yet anyway. I'm president of the Apartment Owners Association of California. We're one of the largest individually organized groups of apartment owners in the state. And I got an email the other day from one of our members, and she was telling me about a couple cows. And the illustration here, of course, represents the crisis that we have now in housing. But you have two cows. You gave a lot of sacrifices to buy those two cows because cows are expensive. You didn't go on vacations. You didn't buy a new car. You didn't go out for expensive dinners. You saved your money while your friends were spending their money. They were not able to buy two cows, but you did. You purchased two cows. Now, you're milking those cows and you're selling the milk. And you're doing okay. You're making up for all the sacrifices that you made to be able to provide milk for the population. Now, the price of feed started going up. And your expenses started going up to the point where you're not making any more money on your milk. And also, the politicians then came in and they said, we're going to put price controls on milk because this is just terrible. The price of milk has gone up 20%, and we can't stand for that. They can't stand for it because they have people who drink milk who are complaining to them and saying, I'm not going to vote for you if you don't do something about this milk. So they did something about the milk. They put price controls on it. They controlled the price so that you couldn't sell it at a price high enough to pay for your feed. So what did you do? What are you going to do? You own the title. Well, you say, I'm going to sell my cows. So you sell your cows to a developer, somebody who's going to do something with those cows. He cuts them up into beef, and he sells the beef and makes good money off that, right? Or in case of housing, that apartment building, he tears that apartment building down. He builds another apartment building where the rents are going to be sky high now because of the cost of the building. Why does the building cost so much? Well, all the laws and regulations to build buildings drive that price sky high, so we have to charge more rents for that. But on the cows, in regard to the cows, they cut up the cows, sold them for beef. Now the politicians are complaining because they have a shortage of milk cows, and they have to blame somebody for that. Well, they have a shortage of housing, don't they? We have a housing crisis. And who do they blame? They didn't blame the fact that they put price controls on milk or price controls on rent. They blame the people who are providing the housing. Doesn't make much sense, does it, folks? These politicians have one goal. And you say, Dan, I don't understand. Why do they pass these laws? It's easy to understand. They have one goal, and that's to get reelected. And there are more tenants than there are owners. And so the tenants say, I won't vote for you unless you provide me with free housing. So what do we have today? You have a problem. That's one reason why a lot of you are listening today, because you have a problem with providing free housing to some of your tenants. Now, the smaller owners have a bigger problem than the large owners who are listening. If you have a lot of buildings and you only have 3 or 4, you can absorb some of that cost. But the state and the city and the county, these people that you re-elected, are asking us, 1 or 2% of the population, to bear 100% of the cost of housing. It's not right. It's bad for the tenants. It's bad for the economy. It's bad for everybody all the way around, except for the politician who gets reelected. Everything is going just fine for him. He keeps making a lot of money, probably more money than he's ever made in his life. In addition to, we've read lately about some side money that many of the politicians also make. Have a couple things I'm going to ask you to do. I'm going to ask you to help. What is the solution to this? We have the problem. What is the solution? Number one thing is to petition the politicians to do what is right and which will be best for everybody concerned. And we have 2 petitions we're asking you to sign, asking you to go to aoausa.com, click on our home page. Not right now, you don't want to click off here. But go to our homepage after this is over, sign both of those petitions, send them to the mayor, send them to the governor, send a copy to them. Just send them a copy of the petition. Ask them to sign it. It'll be there. They'll be invited to do that. They're not going to do it right away unless they're working on making petitions, but these petitions have been successful. It's not the only thing, but all your politicians now are talking about providing vouchers for tenants. If they provide the vouchers for the tenants that have to be paid to the landlord, with these vouchers, then the rent will be paid and the landlord will be able to pay their rent and all the other expenses if the vouchers are done. Now, we don't like the terms of the vouchers that they have, but at least they are talking about giving the money to the tenants and making it go. So sign those petitions, go to that page, sign both of them, get it going. If we get tenant vouchers, then you are going to be paid. All housing providers will be paid for those tenants who choose not to pay their rent. In many cases, some cases they just can't do it. And you want to handle that problem depending upon each individual tenant. And also in November coming up, you have another thing coming up against you. Number one, we have Son of Prop 10. You're going to have to, if that passes, you will lose your vacancy decontrol. You will lose it. In other words, those of you who have low rent, you're renting a 2-bedroom apartment for $950 a month. And normally you could raise it to the market, which is $1,800 a month maybe for that apartment. And now, if this proposition passes, you're not going to be able to do that. Maybe 15% max on that proposition that's coming up. You want to defeat that, and it's going to take hundreds of thousands of dollars to defeat that proposition. You have another proposition that's going after Prop 13, and they want to raise taxes on commercial property. So they want to release it from any tax limitations on the property, and so that they can raise the property at will, the taxes on the property at will. You want to defeat that. Now you say, well, Dan, that's only for commercial property. I only have an apartment building. You're next. You're next. Do you want to stop it now, or do you want to try to stop it later when you won't have the commercial people helping you to stop it, because many of them will then say, well, we're already being taxed. It doesn't matter to me if they tax the apartment buildings too. So that's what's coming up in the future. And again, as we mentioned, it's going to take millions of dollars to do it. Now, what are we doing about the eviction? Pacific Legal Foundation has filed a lawsuit against the Judicial Council. The Judicial Council has shut down the courts so that you can't evict the bad tenant, shut down the courts so that you can't evict the tenant who can't pay rent. So it's frozen. You can't run your business that way. They know it. They want you to provide free rent. So a Judicial Council should not be making law, and that's what they're doing. And so that lawsuit, we should win that lawsuit. Pacific Legal Foundation. We are supporting Pacific Legal Foundation with that lawsuit. It seems to be the only way we're going to get justice is to go to the courts. And again, that takes millions of dollars. I'm going to ask you in closing for me and turn this over to Jeff and get on with our speakers today. To do that, whoa, I lost myself here. Go to the petitions, sign the petitions, go to the website, also make donations to the AOA Political Action Committee. You can send them in through the mail. You can do it on the internet with your credit card, but we do need the money to pay for these. Now, many other lawsuits have also been filed against these things, and so it's going to take time for those to work its way for the court. I want to welcome you today, being on the program. I want to turn it over to Jeff Fowler now so he can introduce our speakers, and we'll move on with the program. I want to thank you again very much for being here. You're in for a real good hour in the future. Thank you.
Take the whole thing. Great, thank you for tuning in today. We have is a property manager, so you're going to get a property manager's perspective on this COVID crisis. And then the second is an attorney, so you'll get the attorney's perspective. And before we get started, I just want you to know we will take questions at the end. So save those questions And if you are viewing this from the AOA website, aoausa.com, you'll notice in the bottom right-hand corner that there's a little chat box. And you can submit your questions into that box. And also, if you're watching from YouTube directly, you can submit questions there in the thing at the bottom. And on another note, this will all be recorded, and if you are a member with AOA, you'll be able to come back to this resource and listen to it again. And that's if you just log into the member portal. So that's one of the benefits of being a member. And I just want to take a moment. AOA, Apartment Owners Association of California, is really here for you, and our goal is to help you make and or keep more money than ever before. And we want to make being a housing provider, we want to make it easier and more enjoyable for you. And so everything that we do, whether it's the magazine or anything else, even this broadcast today, the goal is that you'll get at least one idea from it that will help you in what you're doing as an apartment owner. And other things that we do at AOA, one thing is we offer forms, and we update those regularly. We updated them just even a few days ago. Anything that needs to be updated, we update it, and you'll notice that. And things that don't need to be updated, we leave them, and you just can continue to use them. So check those and see what's there. And we also have AOA Tenant Screening, and this can be accessed online, and you can also call in. And the tenant screening, we've had a couple updates this last month. The eviction searches have been enhanced, so they're working even better than before. Also, the credit check, right now, it used to be where if you ran a credit report that it would appear on your applicant's credit history, and it no longer does that. They call it a soft pull. So it's now a soft pull, and that's good for all of the people that might apply to rent one of your units. And I don't want to forget to mention advising. You can call in from 8:30 to 5 every day. You can call in and ask questions to our landlord-tenant advisors. And we also have a debt reporting. You owe it to yourself. You owe it to the industry. If someone has not paid you, and it's not COVID related, you need to report that so that the credit bureaus have that information, and we have a service for you that you can use. And we also have local offices that you can go to all throughout the state. And currently, because of COVID, all of our advisors are working, thank God, but the offices are closed to the public, so please be aware of that, and we will announce it when those open back up, and we're preparing for that. We have a political action committee that Dan talked about. Please sign those petitions. Subscribe to the e-news. Whether you're a member or not, you can subscribe to that, and also get on that political action mailing list. And when you do, we have it set up so that you can email directly to your representatives. It's set up, it's computerized. All you have to do is put in your name, your address, and that'll work for you. Rarely, but sometimes, there's a verification code that it asks for. This is simply because you don't have to create an account, but sometimes they have to verify that it's actually you that's sending that. So sometimes that happens. And just be aware of that. We also have Livable, who's a partner with us, and they run a RUBS program. And they're offering, they have a great deal. So call in and ask about that. We also have apartment insurance. And again, you can call in and ask about it, and we can fill you in. All these things we've screened and selected, and we believe that we're giving you the very best. And anyway, so now we get to it. Our first speaker, he is the owner of a property management company in the East Bay area, and he currently manages 500 units, and 150 of those are multifamily. And he has been managing properties since 1982, so he has tons of experience, and just really a tremendous man. He's also not just a property manager, he's also a landlord, like all of you, and he's a renter. So he's in a unique situation where he's doing all of those things. Additionally, he's a pastor. He's a licensed pastor, but full-time he's working with this property management company. It's called East Bay Property Management. You'll want to remember that if you're up in the East Bay area. And ladies and gentlemen, it's a pleasure to introduce to you Mike Connolly. Thanks.
Thank you, Jeff. So glad to be here, coming through the AOA offices for the first time. I've been part of this organization since I got into the property management business, and it's just such an awesome organization. I'm just glad to be here to share for about 15 to 20 minutes with all of you what I hope to be very relevant property management information. I'm going to take some of my tools, tricks, and techniques and just share them with you. But before I do that, I just want to provide a little bit of humor to get us going. We could use humor during the COVID-19 lockdown. And what you have is a landlord. He owned not one, not two, but 5 apartment buildings here in California. He'd built up a phenomenal portfolio. So he had these buildings that he was managing himself, but he also had a son who was very lazy. Just graduated from college, took him 7 years, and his son really had no ambition, no goals. So the father had an idea. So he came to his son and he said, "Son, here's the deal. I just changed the title on all of my apartment buildings so that you and I are 50-50 owners. You're my partner, you're on title, and we own these apartments together." And the son said, "Oh, Dad, thank you so much. I don't know what to say." And the father said, "Well, I'm going to tell you what you need to do now. You need to go to work. You're going to be working outside, doing all the rehab of these buildings, all the gardening. Anytime we have a turnover between tenants, you're going to be doing the work. We've got to put you to work, so get out there." And the son said, "Dad, you know me. I'm not real good with my hands. I really don't like swinging a hammer. And when I get outside, I get sunburned, Dad. That's not really the role for me." And the father thought about it and said, "Okay, son, here's what we're going to do. We're going to put you on the inside. You're going to be in the office. You're going to be handling leases. You're going to be collecting rents. You're going to be screening tenants. You're on the inside." And the son said, "Dad, you know me. I'm an organizational disaster. I'm no good at keeping files. I get claustrophobic when I work inside." And so the father was exasperated. And he said, "Son, I just made you 50-50 partner in my properties. You don't want to work outside. You don't want to work inside. What am I supposed to do with you?" And the son looked at the father and said, "Buy me out." Okay. So that's the joke that I tell landlords in my seminars 4 times a year. And the people that have to be at that seminar, some of my staff, are so tired of that joke, but hopefully it made you chuckle a little bit. So we're going to move through, over the next few minutes, some PowerPoint slides, starting with when the tenant says, "I need some help with rent." Now, I manage 500 properties. About a third of them are multifamily, and I have had about 50 tenants in the last 4 months call me, connect with me and say, "Mike, I need some help with the rent." And we're all trying to play kind of like a psychologist here with our tenants. What are they thinking? What are they going through? And we're trying to put ourselves in their shoes. So the first thing that I can say is that you need to be very firm but compassionate. You need to show a lot of discernment when you have a tenant that calls you and says, "You know, I'm having a difficult time with the rent payment." So I remind them that the owner of this property, myself, has obligations also. So I've got a mortgage. So when I'm speaking to a tenant, I often say that my owner has expenses that are greater than the rent. So he's not being forgiven with his mortgage, with those expenses. You're living there. We've got to find a way to pay the rent. I remind them that they've got a stimulus check that has come, that most of them, about from what I gather, 2/3 of all people not working right now are collecting unemployment plus about $600 a week in additional unemployment benefits, which are preventing a lot of people from wanting to go back into the workforce. So you remind them of that. You remind them that they've got to maybe borrow some money, savings. So I run through all the avenues. I don't lay down for my tenants. And but then again, some of them, when I hear the stories, and I'm very discerning, I say, okay, their income is affected here. They need some help. So the first thing that you want to do is there is forms, they vary by county, on how the COVID virus has affected income. So the form basically gets in writing that, yes, here is proof that my income has been affected, and here's how I plan on making full payment over a period of time for my rent. So sometimes I get that form to them, sometimes I don't. If because everything is fluid here, we move month to month. But what I often do is give them a choice where you can either take a rent reduction of $100 to $200. So if it's for instance, if it's a house and it's a $3,000 rent, I'll offer a $200 rent reduction. Our company, our property management company, pays $100 of it. I get $100 from the owner. So I give the tenant that choice, giving them the choice of taking that or splitting the rent payments, paying half on the 1st, half on the 15th with no late fee. Usually they take the $200 reduction. So I share that with the owner. So if you're having a property manager manage your properties, you want him to participate in any kind of rent reduction. So split the payments and waive the late fee. That's a great second option. And they have to choose one. So, and believe it or not, they're very appreciative. They'll say, hey, every little bit helps. And then they're going to ask you, can we make this for a period of months? And you want to say, no, we're going to take it month to month, because with this virus, everything is so fluid, everything is changing day by day, that you don't want to commit yourself for more than 30 days. If they ever ask for rent forgiveness, absolutely not. And if they ask for deferment, I say no, because the chances of them catching up down the road are very small. So I never want to say yes to forgiveness or yes to discernment. And what this pandemic has done is it has reinforced to our company the how grateful we are that we screen our tenants so carefully. The number one criterion that we use in screening a tenant is credit score. And there's nothing that's even a close second. Not income, not a landlord referral. It is credit score, because the credit score tells me two things. Number one, it tells me if they've got a good credit score, 680 or higher in all the cities that I manage in, up in the East Bay of Northern California, must be 680 or higher. It tells me that they have been responsible with their financial transactions in the past, so they've been diligent there, and that they have a lot to lose. Because if you haven't, if your tenant is evicted and you contest it, then their credit score is going to be affected by about 100 points. So when you have a 700 plus credit score, you're not going to have a problem with evicting your tenant. So I do not budge on the credit score. When somebody says, Mike, my credit score is not 680, but make great income, you can check with my landlord, I've been there 7 years, I don't carry the conversation on. I excuse myself. I basically say, this is what I've advertised, 680 or higher, I've got to stick to what I advertise. So the AOA offers a phenomenal tenant screening program. So when I'm speaking to a prospective client, he's managing his property himself. If he's not a member of AOA, and I let him know about AOA, and I want to let him know about their tenant screening. because it's excellent and it's so affordable. So for my tenants to be screened on the software that I use, it's not cheap, but with the AOA, it's affordable and it's quality screening, probably actually a little better than the screening that we use. So that's when the tenant says, I need some help with the rent. Now, here's some other tenant issues. I offer a little extra compassion during this time. One of an example of this is a gift basket that I happen to personally deliver to almost 500 of my tenants. I wanted to, number one, it was a good exercise for me. It took me about 7 or 8 days of driving to all my cities, but it allowed me to see every single property from the outside. And in this gift basket, I open it up, of course. You've got your roll of toilet paper that says, I survived the toilet paper crisis of 2020. We've got playing cards. We've got, this is something for the grandkid, a cute little teddy bear with a COVID mask. Then you've got a nice journal that says, make hand washing great again. A calendar that goes on the refrigerator. Oh, there are about 20 different items in this little gift basket. And it just is, again, showing your tenant that you're thinking of them, that you care about them, and however you want to demonstrate that you're compassionate for the situation that they're in with the pandemic, because so many people are genuinely hurting. Now, when it comes to maintenance, one thing about our maintenance is that we require in our lease that the tenant allow us to come in once a year to inspect their property. Now, you're not able to do this legally in California. You can't just go in to inspect your tenant's apartment unless you have their permission in writing, and that's why we write it into our lease. So that might be an addendum if you don't already have it in your AOA lease that you want to add when the lease is renewed, that you're going to be allowed to go in once a year and inspect the outside and inside of the property. This is crucial for us because we want to make sure the smoke alarms are working, the carbon monoxide alarm is working, that we don't see any leaks on the roof or on the ceiling, that there's no mold issues in the bathroom. So that's we look under the sink. We want to make sure the tenant hasn't snuck in a roommate or a pet, and that the tenant is taking care of the home. So this we have continued to do during the pandemic. And if you're not inspecting your property once a year, put it into your lease. It's crucial, because to be offering a lower than market rent to your tenant because he's taking care of any maintenance issues is a recipe for disaster. They are going to postpone deferred maintenance that you should be doing because they don't want the rent to go up. They don't want you to have to, put money into their unit and see their rent increase. And so, we're with these inspections, actually we're postponing those inspections until the fall. We're doing maintenance as usual for everything else, whether it's emergency or non-emergency issues. That hasn't changed. You cannot let the tenant say, listen, I don't want somebody coming in to fix something because of the pandemic. Then when it comes to lease extensions, all of our tenants begin their lease with a 12-month lease. So, and then when the 12 months expires, some of our apartment owners like to see a 1-year lease renewed every year, and some don't mind if it goes month to month. I personally feel that a month-to-month lease slightly favors the tenant. They can give you 30 days notice at any time. Meanwhile, you have to give them 60 days notice if they've been there longer than a year. I don't like a tenant giving notice in November or December. It's a little more difficult to rent. You can't get quite as much money. So if I'm signing up a tenant in November or December, it's an 18-month lease because we like our leases to expire around May or June. And But during the pandemic, if you have a tenant's lease expiring and you're thinking of renewing the lease for a year and they want to remain a little fluid, I have no problem going with a 3-month lease or month-to-month until we get past this. So that's been our policy on lease extensions. I don't like adding roommates. When you have 2 tenants in a 2-bedroom apartment and they've signed the lease, I remind them, I just want it to be the 2 of you. I don't want you to add any roommates. Now legally they can, but you just let them know that you're you don't want a youth hostel here. You want you've got a 2-bedroom apartment or a 1-bedroom or whatever it is, and the tenant's on the lease. That's what you'd like it to stay at. But if they add a tenant during the lockdown, or if the tenant is replacing an outgoing person on the lease, we charge, actually it says $295, we charge $195 to who's ever moving in. And so we want a little bit of compensation for that, and I believe you could charge the same. When it comes to lease breakage, I would say probably 1 out of 20 of our tenants break their lease somewhere in the 12-month period. And that's no problem if they want to do that. Of course, they're responsible for the rent until the new tenant moves in. And we always charge the tenant breaking the lease a 50% of 1 month's rent lease breakage fee. So it gets them thinking twice about leaving the lease early. So if they're renting a $2,000 2-bedroom apartment and they want to break the lease, we're going to get $1,000 to post ads on Zillow, which are going to start costing money in July, by the way, and marketing the property. You want to be compensated for that. So if that's not written into your AOA lease, I would add it so that you're not only getting rent until the new tenant has moved in, but you're also getting some money for showing the property, marketing it, and so forth. And then finally, with rent increases, this is a tenant issue. I have, because what we do, most of our tenants are on a 1-year lease. Even if they're on a month-to-month, I'm renewing the rent or reviewing the rent every year. I do a rent analysis. We use a software program called Rent Range that takes your apartment and pulls out 10 similar apartments in age and square footage in your neighborhood and gives you the median rent. It's a good starting point. So it will let you know if you need to increase the rent in a given year or keep it the same, and in some instances even lower it $50 or $100. But if the rent's going to be increased, it's not a good look to do it during this season with the pandemic. So I do about 30 to 40 lease renewals a month, and I have decided to postpone. If I see a rent increase, they're going to get it, but it's not going to happen until the fall. Maybe even later than that. We just are going to take it month to month, but I've made a notation that they're due for a rent increase. Now, when it comes to turnovers, what I would say is this. What I'd like to do is go through the property 2 to 3 weeks before the tenant is going to vacate. I want to determine the rehab that's needed once the tenant vacates so I can hit the ground running. If they leave on the 30th, I'm in there with my vendors on the 1st and we're doing the rehab. So that's the first thing that I always do when I know a tenant is given notice. Then when I go in and I look at the unit 2 or 3 weeks before they vacate, sometimes 3 or 4 weeks before, I want to see if it's possible to show the home, to show the apartment while the tenant is still residing there. And the way I make that determination is this property a 9 or a 10 on a 10 scale in terms of showability? Is the tenant an excellent housekeeper? Do they have nice furniture, not a lot of clutter, not a lot of boxes? If that's the case, then I would ask the tenant's permission to show the property. He or she takes a 15 or 30-minute drive while you show it to 2 or 3 prospective parties, and that way you can minimize your vacancy. So when the tenant, because whoever likes the property has to give typically 3 or 4 weeks notice to wherever they're living. So if you can reduce the vacancy by showing it while the tenant is still there, more power to you. But it has to be a 9 or a 10 on a 10 scale. If the apartment is messy and cluttered, I won't show it, because all you're going to do is create unmet expectations to a prospective tenant who decides to take it, but then when they move in, they say, oh, I didn't realize this looked like that, or that you weren't going to repaint this room, that the carpet looked like this. It creates more trouble than it's worth. You're better off getting it vacated, getting it clean, rehabbed and cleaned, and then beginning to show it. When I do show a home with the tenant still living there, show an apartment with the tenant still living there, I'm very careful during these times. I want the tenant to leave, and I ask them very nicely to take a drive or a walk. I'm going to be with the prospects the entire time. Our shoes are off, our masks are on. I ask who's ever going through the apartment with me not to touch anything, and only one party at a time. So typically at an open house, I have 2 or 3 parties there, and you only want one party at a time. If they have kids, I have the kids wait outside. The less people going in, the better. But that's how I've been handling my turnovers. And when it comes to rehab, you can see this on my website. I always walk in, usually I'm walking in to do rehab with the owner and the tenant. They've given us permission to look. And I've got my rehab board with me that shows the type of flooring that I'm going to recommend. If you've got linoleum counters, maybe we can talk about quartz or granite. We talk about paint, blinds. So I've got my rehab board, and what I typically do is let my owners know there's 3 ways that you can do rehab. You can either do it with your own vendors, you can use my vendors and work with them directly, or you can use my vendors and I'll oversee their work, make sure it's done properly, on time and on budget, and you're going to pay me a slight oversight fee. But rehab is key, because I always remind owners a good apartment attracts a good tenant. An average apartment attracts an average tenant, and slightly below average is going to get a very rough tenant. And life is too short for average tenants. So it also adds value to your apartment building, and it is going to allow you to get more rent. For every $1 you put into rehab, you're going to get at least $1.50 back in added rent. I never make a recommendation to an owner to do a specific to do specific rehab unless I can quantify to them how much more rent they're going to get. You put in a quartz counter here in this kitchen, that's worth at least $25 a month in rent. If we can get rid of this carpet and put in waterproof laminate, that's worth another $50 a month. So it pays for itself in just several years, and then everything after that is profit. I've got on my website several videos on the rehab that I recommend for apartments. And if you'd like, you can go to my website, eastbaypmc.com. I've got a number of forms on my site. There's some COVID-19 forms. I've got a couple of great videos. One video is entitled The 12 Basics of Property Management, where I share, again, a lot of tricks of the trade that could help you as a self-managing owner. And I've also got a great video on should I hold, sell, or exchange my rental property. And I look forward to doing live seminars with the AOA and continuing to be a partner with this great organization. Thanks for watching. Happy landlording.
Great, thank you, Mike.
My pleasure.
Shake your hand. Oh, I would shake your hand, but COVID. So, yes, in our next next speaker, he has been working for 20 years practicing law. He is the chair of the Burnham Brown, at Burnham and Brown, and approximately 90% of his business is in real estate transactions and real estate litigation. So he's an expert. He represents landlords, property owners, and property management professionals, as well as businesses and parties involved in real estate transactions and disputes. This includes leasing, simple and complex, unlawful detainers, habitability, and local ordinance compliance and litigation, as well as environmental matters, disclosures, due diligence, and mobile home and residency matters. And in what little spare time he has away from work and family, he loves to play the guitar and loves to go fishing. And it's my pleasure to introduce to you Chuck Alfonzo. Chuck, are you?
Hello?
Hi, Chuck, are you there?
Yes, I am. Can you see me?
Yes, I can see you. I think we're ready to go.
Oh, I'm sorry. I was waiting for the A-OK from our IT people. So if we're live, then we're good to go.
Thank you. I see a lot of guitars there behind you. You must really like playing the guitar.
Yes. Am I ready to go now? I'm sorry for this. It's just unclear. I'm waiting for the IT to say.
I believe you are.
Okay. Well, I'm going to start talking. If that.
Yeah, you're good. You're good to go.
Okay. Well, hello. Thank you for the kind introduction, Jeff. Today, we're here to talk about navigating and understanding the COVID-19 issue as it applies to landlords and residential properties. I'm going to dispense with a lot of my own introduction. Jeff did a great job. At the end, you'll see my name and my contact information if you need to get a hold of me. But there's a lot of material that I sort of want to go through with you, and it has two aspects to it. One is understanding really what we're dealing with legally, because it applies federally, state, county, and city. It goes on all jurisdictional levels. We have to sort of coordinate all of that as we're talking to our tenants and entering into agreements. And then also I'll provide some tips with what I've found useful in terms of negotiating with tenants, claiming at least during this time, they're unable to pay. At this point, we're seeing approximately 85% of the tenants are paying, and that's going to differ from landlord to landlord. In the Bay Area, we have some tenants that are going on rent strikes. You can have an entire building not paying rent. And as you can imagine, that can be catastrophic because your obligations to maintain habitable premises has not changed. Your obligation to pay your mortgage payment, if you have one, to the bank, that hasn't changed. You got quarterly taxes. We all know what that involves. So one level, again, understanding what we're dealing with, and then hopefully some helpful tips. Right now, as I said, about 85% is what we're hearing, and that's good because the way that the eviction moratoriums have come down, there's been a lot of protections that have been put in place for tenants, and that's understandable, but we have not seen similar legislation come in to protect landlords and property owners. And that's causing a disconnect. We have a real problem. You have a situation where the government on many different levels have told people, hey, you can't go outside. And we know that that is, being eased, but right now we're still in the state of emergency and they're preventing people from engaging in everyday activities. That includes finding another place to live. And if you're working at a restaurant and you're fist to mouth, month to month, and you're relying on your job to make some money, you don't have that money to pay rent. And the government has stepped in and said, okay, generally you're not going to be evicted for a certain time period. The problem with that is not that it's not addressing it, but it's that it's shifting what we have as a societal burden onto the backs of landlords without similar legislation and similar protections for landlords. So I'm going to first start off with what we have as the legislative environment. And I'm going to put up a screen that hopefully you'll be able to see. Where's my profile? Okay, so I'm going to share the screen with you. Oh, you've disabled screen sharing. Are you able to put on screen sharing for me? IT? Okay. It would be easier if you're able to. I apologize for this interruption, but generally there is federal, state, county, and city legislation. Federally, you have what is called the CARES Act, and that's a specific response to COVID-19. If you have a property that is covered under the CARES Act, eviction moratorium in place, that was enacted March 27, and it stays in effect for 120 days. So the expiration date is July 27th. That's a key date. Now, what does it mean to have a covered property? It's pretty broad. And if you have HUD financing, if you have a low income tax credit property, if you have Section 8 tenants, all of those types of relationships with the federal government will allow protection to the tenants, and you're not allowed to evict during the 100-day period. Issue follows after that is that it has, after the eviction moratorium is over, if you issue a notice to terminate tenancy with those properties, instead of a 3-day pay or quit, it's going to be a 30-day notice. So they've changed the law federally. And again, it matters if you have federally subsidized housing or the tenants are receiving federal subsidization. The other way that it can apply, and we see this a lot in Oakland, are in single family homes that are backed by federal mortgages or subsidies. So if you have a VA loan for your property, you're going to be subject to that federal eviction restriction. You have a HUD loan, right? Fannie Mae, Freddie Mac, all of those types of loans will loop you into this federal law. And again, the main points of the law is that there can be no eviction for non-payment during the term of the emergency. And then after the emergency is over, if it doesn't get extended, then the new notices will be 30-day notices. It does not apply, obviously, if you have your own home and there's no federal subsidy there, then you don't have to worry about it. If you don't have low income tax credit properties, Section 8 tenants, you don't need to worry about the federal legislation. So there's a carve out. The other carve out on the federal level is that it only applies for non-payment issues during the pandemic, and those non-payment issues are supposedly related to the pandemic. So if you have health and safety issues, if you have other breaches of the agreement federally, that's okay, and you can move forward. The next level of legislation that we have is state. And on the state, you have two sort of running issues. You have Governor Newsom, who has issued a stay on evictions, but the way that he did that is he has given authority to the local jurisdictions to enact their own moratoriums. And that is in place right now through July 28th. With that authority, he has also given power to the courts through our judicial council to halt evictions. And he's actually given a directive that no evictions except for health and safety can move forward. And health and safety, as you can imagine, is you have an angry tenant, they show up with the gun, they're in the manager's face, they're threatening the manager, they're threatening another tenant, maybe they got a meth lab, something like that going on. Those are real health and safety issues. I'm going to talk about this really quickly because it sounds like there may be a remedy for health and safety when in many jurisdictions, unfortunately, there's not. So for example, in Santa Clara County, even though the order says that there's an eviction on all evictions, there's a moratorium on all evictions with the exception of those based on health and safety, the local rule that's been enacted says we do not have a mechanism to make a determination as to whether or not this eviction is truly based on health and safety. Therefore, you can't come to court until our moratorium is up. A very similar situation has happened in Alameda County. I can tell you now that a group of tenant attorneys and a group of landlord attorneys are talking with the courts in Alameda and the presiding judge trying to get this procedure in place. And it's another battle between property right groups and the tenant groups. The tenant groups are essentially trying to make it a mini trial. Sometimes you can go in ex parte, you just get a declaration from the landlord saying this is what the health and safety reason is. Maybe that's enough. The tenant groups want to have a hearing on it and they want the tenant to be able to respond. And you have to understand, this only allows an eviction to move forward, right? You can file it and then go get it served. You're still going to be stuck in eviction land, and whatever jurisdiction you're in, it's going to take as long as it takes in that jurisdiction. And sometimes that can be lengthy. It's just trying to get it filed. And right now in Alameda County, we do not have a procedure to actually get that done. And I'm hearing horror stories of, like the examples I gave you, of some tenants that have gotten in the landlord's faces, they've gotten in the property manager's faces significantly to where the police are being called out. And maybe you'll be able to get a TRO to keep them away, but you're not able to do anything to remove them from your property right now. And the reason for that is that the government, and the reason for the entire eviction moratorium, it's not as nefarious as it may sound or how you feel when you realize, hey, I don't have this remedy. The idea is that, hey, the government is telling people they can't go out, you can't do anything. And we don't want to displace people from their homes or your properties just to increase the significance of the impact of COVID-19. Again, it's a real problem. It's a societal problem, but I think it's been disproportionately pushed onto landlords to try to deal with it. And I won't get into the politics of that. That's just my thoughts. On that county level, there's something else. If you've been involved in UD proceedings before, you know that most times those cases don't go to trial. Usually those are resolved through what's called a stipulation for judgment. And you may pay the tenant some money, they may have a certain amount of time, but ultimately they're required to leave by a date certain, probably pay you back some money. And if they don't, then you get your judgment, you go to court, you can then take it to the sheriff and they will remove him. There is a huge backlog of those. And at least in Alameda County, we're not able to get those through right now. So we have stipulations for judgment that were entered into prior to COVID-19. I think March 17th is the key date there. Everything was done beforehand. They were required to move out perhaps during a time that we're in this state of emergency. And I have several cases like that. And the tenants have just said, look, we're not moving out. There's nothing we can do. We can't find another place to stay. Well, your normal remedy would be to go to court, say they didn't move out. What we have found in San Francisco, and I expect that it's going to happen here in Oakland, is that the EDC, which is the Eviction Defense Center, and there's similar groups like the East Bay Community Law Center, various tenant right groups, they're arguing that these contracts and these agreements are unenforceable due to COVID-19.
Hey, Chuck,
I can tell you right now that there is some briefing going on in San Francisco on that, but we do not have a decision. I'm sorry, was there a question, Jeff?
Oh, yeah, just real quickly, you are able to share your screen now?
Okay,
I
great.
just wanted to let you know.
Thank you very
Go
much.
ahead. Sorry to interrupt you.
No worries, no worries. I'm going to finish this thought and then I'll go back into the screen. That is an issue that a lot of landlords are facing, and I wish I had good news for you. But right now, unfortunately, I see that landlords are essentially being shut out of court. And I can tell you that my own caseload, most of my cases are getting continued. We were set in May, June, July. Now they're getting pushed into August and September. And because the backlog in the courts applies to all cases, not just unlawful detainers or landlord-tenant matters, or even, by the way, regular real estate matters. If you have transactions, which is a big issue during COVID-19, a lot of people are backing out. Some people are trying to keep deposits that have been lost. And that's a whole source of probably another topic, but that's something that's happened due to COVID-19. On this issue of the stipulations, because you're unable to get to court, and as I was saying, the court has this other backlog. Most of the judges that I've been speaking with and the commissioners, even if it's set, they don't think that you're going to be able to actually have a jury trial until probably sometime in 2021 or late 2020. The reason for that is there's going to be great difficulty in picking a jury, and the juries are going to get first pushed off on criminal matters. Some matters might be environmental, where you have what's called living mesothelioma. You have people that are dying, they get preference. Even though unlawful detainers are entitled to preference, I can tell you the court's reaction has been, you're going to wait. So you don't have a huge remedy now, and it's going to be difficult to get into court. That is going to inform, I believe, your decisions with your tenants later on when we start talking about what is the best practice when your tenant says, hey, I can't pay. You have to have that understanding in the back of your head that you really may not be able to get into court. And if you do get into court, it's going to be a long ways off. If you're in a jurisdiction where there are tenant defense groups that just, they do it for little or no pay, and you always run into them, like the Eviction Defense Center, La Raza, or East Bay Community Law Center, what have you. There's similar ones in most jurisdictions in the Bay Area. They work semi-united, and I can tell you, I've probably seen one case where we had a judge trial, and that was on specific circumstances. They almost always will request a jury because why? It's more expensive for you. They may be able to extract more in the negotiation if the case settles. Most of the cases settle. So we got a huge backlog, and people aren't really sure what we're going to be able to do. Understanding in the context of what I've been saying, we started with federal, you have state. I told you about the Judicial Council restriction on evictions, except for health and safety, some of the issues associated with that. To complicate matters, you also have counties now and cities within those counties enacting their own eviction moratoriums. Most of them have different dates for enactment and conclusion, and some of them have different rules for when somebody has to pay back, what documentation, if any, they have to provide if they're claiming inability to pay. I'm going to explain that in just a second here by example. In the counties, the jurisdiction as to what applies, what law will apply, varies. So for example, in the county of Alameda, there is an eviction moratorium, and right now it's being hotly contested, but it's in effect. And that moratorium says that it applies to all of the unincorporated areas in the county, as well as all of the cities. That's unusual in Alameda. Normally, if the Board of Supervisors in Alameda enacts legislation, it usually only applies to the unincorporated areas. Each city will enact their own legislation. they've taken the step here to apply to all cities. And what the legislation says is that if a city has their own moratorium, it really doesn't matter. The county moratorium will apply, and the rules set forth in that moratorium will apply, unless the city specifically opts out and says we want our city legislation to apply, and the city legislation has enough protections that the county deems appropriate, and they're listed in the legislation. That's Alameda County. A different example is Contra Costa. Contra Costa's county ordinance also applies to all cities within the county and all unincorporated areas. It says, however, that if there is a city legislation or a city ordinance on eviction moratoriums and it covers the same subject matter, then that city ordinance applies. So there's a good example is the city of Concord. Concord has its own ordinance and it has different timelines than those set forth in Contra Costa. If your property is in Concord, you need to follow the Concord guidelines, not necessarily Contra Costa. The other way that we've seen this happen is a sort of a split, and this is normally what we see in this type of litigation or legislation, and that's in Solano County. In Solano County, it says that whatever legislation is more restrictive and more protective of tenant rights will apply. So Solano County has its ordinance, and it's fairly strict. Vallejo has an ordinance, as does Benicia. Benicia's doesn't have much teeth at all. So even though there is one in Benicia, you're going to follow Solano. Fairfield and Vacaville have legislation. It's in some areas it's a little more protective of tenant rights, in other areas it's not. So when you're trying to figure out what you need to do and what you can do, you have to understand that legislation, and you're actually working with both sets and trying to figure out what is more restrictive and which one do you follow. What we've seen is that in almost all circumstances, the courts are going to look at what is the most protective of tenant rights, and that's because they're very concerned of any type of displacement during this COVID-19 pandemic. And I got to tell you, I think the use of the word unprecedented is overused, but at least in my practice, it is truly appropriate for this circumstance. And that's because you're seeing this rash of legislation, and you're seeing one group, primarily property owners, essentially being shut out of court. And it's to protect, and it may be feel-good legislation, and it may actually even be appropriate in certain circumstances. But what is inappropriate and unconstitutional in certain circumstances is that they're denying the ability to get into court. When you had your contracts and you entered into your leases with your tenants, you understood that, hey, if they didn't pay their rent on time, you would be able to assess a late fee. And you also understood that if they didn't pay their rent, you would at least be able to try to get into court to evict them. That has been removed, and the courts and the laws have said they do not have to pay. And in certain circumstances, the repayment period is a long time. I mean, in Alameda County, they're giving you 12 months from the date it was due to pay it back. And it also concerns your remedy. So after that 12 months, that's when it actually becomes late. Even then, in Alameda County, you're not allowed to collect the late fee, and you're not allowed to evict. You then can go try to get a money judgment. So it has removed your remedy of eviction. And again, it's understandable, but it really places a disproportionate burden, I think, on landlords. Other counties don't have that same remedy. They're allowing a shorter time to pay it back. Sometimes it's 6 months, sometimes it's 90 days. Most of the ordinances do not allow for eviction even after the repayment period. Some do, and it just depends upon what jurisdiction you're in. So I'm going to now try to go to my screen here. If I can do this, and let's do this here. Okay, so we've gone through sort of what the eviction freeze is. I've talked about federal, state, county legislation. You should also understand that the cities, I mentioned this, have their own legislation. Berkeley has its own, Concord has its own. And the real issue there is just making sure you know which one applies, so you can then figure out how to go forward with your tenants. The main legislative changes that have been applicable to residential real estate are the shelter-in-place orders and then the eviction and rent increase moratoriums. The shelter-in-place orders, as I'm sure you know, because it's been all over the news, it requires individuals to stay in their place of residence except when they're traveling to critical infrastructure or essential activity. And then they look at the definitions of what businesses are critical or essential. The other ones were required to stop all but basic operations. We know now in California that those are easing, but we've also seen a recent uptick in the amount of COVID, at least diagnoses and hospitalizations recently. So we don't know if they're going to put us back into the shelter in place or not. What I am hearing is that probably not initially, but if it gets out of control, yes, they'll then put us back into shelter in place. Why that is important for real estate is that real estate was not carved out initially. The last carve out allowed for real estate transactions to move forward. And if you were purchasing a property or you were selling a property and you could get people to show up and you could have your escrow go forward, those types of deals were allowed to move forward. For residential tenancies, that also included, if you had a vacancy, being able to show your unit. And there are some procedures that I will get into later on that I consider to be best practices in doing that. And I still think those still apply, even though they've eased the restrictions. Right now, we have social distancing and we have mandatory mask orders. If you have a larger residential property, all of your employees are required to social distance and wear masks. And you're supposed to have signs up that prevent people from entering the structure. Even your tenants, once they get out of their unit, should be wearing masks and practicing social distancing. There has not been much in terms of enforcement. What we've seen is that the health departments in various counties have targeted certain businesses, but they've been very reluctant to target any individuals. Yesterday, Governor Newsom, because of the tick, said that he thought that we were probably going through some form of amnesia, and that people need to remember that they're required to wear masks and they're required to social distance. We're trying to get our business world back together again, but everyone's going to have to participate and realize that you may be a danger to somebody else. So mask up and stay away as much as you can. What he has threatened to do is to withhold certain COVID funding from counties that are not enforcing it. This just happened yesterday, so we haven't seen anything, but I would expect that the counties now and the health officers will ratchet down, at least initially, probably first on businesses and then on individuals. One thing that I think is important to understand, because the eviction moratoriums are usually tied to the state of emergency. We have the shelter and not necessarily the shelter in place order. So the shelter in place orders are being eased. However, we still have the state of emergency. That has not been affected, and at least the statewide state of emergency does not have an end date to it. So it's just in place. And to the extent that your county or city moratoriums tie their moratoriums to the state of emergency, which we've seen in quite a few jurisdictions, there is no end date. We just, and it's created a lot of uncertainty. The Judicial Council saw this, and I can tell you, I believe it was June 10th, They were scheduled to put an end date and say, look, by July 28th, this is over and the courts can now resume unlawful detainers. They received a lot of complaints from tenant groups as to what does that mean, what's going to happen, and a vote was set to take place and they withdrew it. So right now we have no real end date on the state of emergency or the Judicial Council's restriction on evictions. And the only thing that is keeping it in place, I know it's getting a little difficult because there's a lot of different laws, but the authority by Governor Newsom to the counties is the only thing that has an end date. And as long as there's a state of emergency, the city legislation that's tied to the state of emergency, as well as the county, will remain in place. And even if that is legally incorrect, it will require somebody to file the cases, try to get it up in front of the Court of Appeals, and maybe even the California Supreme Court to get relief. That's going to be slow. So I wish there was better news there, but unfortunately, there's not. We went through the Federal CARES Act. I told you that does expire July 27th unless it is extended. Okay, we've talked about state, county, and city legislation. July 28th is the state date. That's important. I've told you about the restrictions. I've given you the examples. The key features of the legislation are the no evictions except for health and safety, and we did discuss that. What they have put into almost all of the moratoriums, and it's universal from federal all the way down to city, there is no waiver of the rent. What they have said is that there may be legally imposed deferment. And I know that our previous speaker said no to deferment. And I think that's okay, but you need to understand that there's not an enforcement mechanism if they say, we just can't pay. They will remain liable for the rent. But at least right now, the fact that you're saying no deferment, you're not going to be able to move forward and get an eviction. And even right now, you're not going to be able to move forward and get a money judgment. So you're just locked out until probably sometimes near the end of July, and all of these county boards and city boards are going to reconvene. And I can tell you, I've participated in many of those in Alameda, Contra Costa, and Solano County virtually. I've attended and watched what was happening. And what I'm seeing is that the tenant groups have proposed a lot of the legislation. And even though our apartment groups like the Apartment Association of America, California Apartment Association, and other similar groups have provided input and suggestions of ways to move forward, more often than not, they're getting shut down or shut out, even if they get read into the record. Again, they're very concerned about displacement. All of the legislation that I've seen, in addition to saying that there's no waiver, it all says that the non-payment of rent has to be due to COVID-19. And that's for non-payment specific legislation. I can tell you in the county of Alameda, there's a general moratorium on all evictions for any purpose, excepting health and safety. That has an expiration date. But there's also a moratorium for the non-payment of rent if that non-payment of rent is due to or related to COVID-19. So I've written these down here. There's many, many more examples, but it just reinforces how important it is to understand your jurisdiction, both locally, countywide, and then compare that with any federal or state obligations you have. The Alameda County ordinance is currently set to expire on July 20th. Just yesterday, they were set to have a second reading of an amendment to that, and there was an issue with the closing date, which would have required a new first reading. That's how they pass legislation. Introduce it, first reading approved. If it gets approved at the second reading, then it becomes law. It got through the introduction, it got through the first reading, but at the second reading, they realized that they needed to make a change on the end date. Because that change was deemed substantial, it would have required a new introduction and first reading, and they did not believe that they had the time to do that. So there were two levels of legislation that were set to go forward. One required 4/5 vote, and the other one required 3/5 vote. The one that required 4/5 vote did not pass. 3 people voted for it, and 1 voted against it, and 1 abstained. So that may get reintroduced. The second form of legislation that had been there appropriately, they decided that they wanted to push through just so that there was no gap. And that passed 3-5. It only required 3/5. So we're now evaluating that legislation to see what applies and what doesn't. I can tell you that next week they are set to meet again, and they likely will reintroduce some new amendments so that they can get past the July 20th deadline. And all of the discussion that I saw was designed to try to push this out not as far as possible, but definitely out into August and maybe into September. We're waiting and let you know when we get those dates, but this is something that happens sort of every day, and it can get you a little dizzy when you're trying to grab all of the different jurisdictions and put it together in one place. Contra Costa, Alameda, you have 12 months to repay, and that's on a rolling basis. So it's 12 months from April if they didn't pay, 12 months from May if they didn't pay. Contra Costa, theirs is set to expire on July 15th unless it's extended. We know that the state has said that the counties have until July 28th. We haven't seen anything yet, but I would not be surprised if they extend it to July 28th. Currently, all past due rents must be paid in full by November 15th, 2020. And if it's not paid by November 15th, it is only at that time that it's considered late. So you may have had a May payment that they didn't make. They said that they were unable to pay due to COVID-19, and it will not be due until November 15th. And it will not be considered late unless it's paid in full by November 15th. San Francisco, their ordinance goes through 8/30 of 20, August 30th, and they have a end date for repayment of 12/30/20. That is also likely to change, but that is the current state of the law.
Mm-hmm.
During the moratorium periods, there's no rent increases allowed. You can't collect late fees or apply late fees for rents that were not paid, again, that were due to COVID-19.
Great. Now, thank you so much for sharing. We do have questions from people that are watching right now, and I thought,
do you want me to take the questions now, or do you want me to wait until the end? I have a little bit more to go through. If we have time, if we don't, I can start taking questions now. But there's a lot of information, and I apologize.
Right? Yeah, there's so much.
At you really quickly.
So good. There's so many details and so many little things that make a big difference too. But yeah, let's go ahead and wrap up. And if you have one last thing you'd like to say about it, then we could go ahead and we'll have Mike come in and the three of us will take questions.
Okay, I'm going to deal real quickly with the solutions, right? So I've given you the horror story of sort of where we're at. You can and should request proof of loss. So if they're going to claim that their inability to pay is due to COVID-19, you can ask for it and you should ask for it. And my recommended practice is every month that the payment is due, even if they tell you that they're unable to pay due to COVID-19, you send a new notice with the new tally. So when this is eventually over, you will have documentation and you will have a running period. And part of that documentation, ask your tenant, hey, come talk to me. Let's figure out a way to get this taken care of. The next thing that I want to talk about really quickly, repayment plans. All of the legislation encourages people to pay their rent, even though sometimes it's not necessarily written there. Because it's not forgiven, you should be trying to get payment. If you tell your tenants that deferment, you don't want deferment, hopefully you can get them to pay. But the law is imposing deferment. So if they don't pay, they're going to have a certain amount of time to pay it back. Waiver, I don't think you should do, but sometimes if you have a long-term tenant, business tenant, sometimes it's okay. Just 1 second. A mixture, you can do some waiver, some deferment. You got to have an enforceable contract. Get it in writing and work with your tenants, especially tenants that you have good relationships with. Because of everything that I told you, it's going to be more important to get money in your pocket now than to hopefully get it later on. And with that, I will leave it and send it back to you. I apologize for that.
Great. Thank you so much, Chuck. Really appreciate it. You're an expert, and man, there's a whole lot there.
Okay, so if there's questions, I don't know how to respond, but you let me know where they are, and
Great, yeah.
myself or Mr. Connolly can respond.
Yeah, so Mike should be coming on here. Mike, are you there? There he is.
Yeah,
All
that
right.
was excellent. Excellent, Chuck. Made a lot of notes.
Thank you.
Okay, have a little, there we go. So we have questions here, and the whole point with this is we have one of you, Chuck, that knows the full extent of the law. And there are some of our members, some of our viewers in the audience that are just, they have tenants that are gaming the system, and they really need to know what they can do, what their rights are. And then we have others, and maybe they've been a great tenant, never missed a payment in 8 years, sweet people. And I'd say that I hope that that's the majority. But if you're watching, maybe you're watching because this is a painful place. But in that case, we want to keep the tenant. And I think Mike is great at answering how to keep the tenants there. So that's the whole vision behind having both of you on at the same time. And so I'll go ahead and I'll ask this question. And and so with all the answers, let's try to make them short so that we can do a rapid fire and get through as many as we can. And so the first question is, are some of the rent controlled properties not subject to the rent freeze because of the Ellis Act? And Chuck, I'll let you answer this one.
Certain of the eviction moratoriums, like in Oakland, carve out Ellis Act. The county, for a certain period of time, prohibits any evictions, but usually Ellis Act evictions are excluded from the moratorium generally.
Great. Okay, here's the next one. Due to COVID-19, cities are giving tenants 6 to 12 months to repay back rent payments. When a tenant is moving out now, can the owner take the unpaid rent back from the security deposit? And Mike, I think he'll be good to answer this one when regarding the security deposit.
Well, to be perfectly frank, of my 500 tenants, I have just a small fraction, maybe 5%, 25, that I've had to make rent deductions to. I am not deferring any rent, so I'm not familiar with including that in the deposit deduction once the time comes. Maybe Chuck is.
Yeah, Chuck?
I believe that you can. There's certain reasons that you're allowed to take it, and because it is not waived, it would be considered a reason to take money from the deposit if they leave while they owe.
Okay, here's a good question. Is there any law that says apartment building pools should stay closed or that they ever had to close down?
Yeah, I know we have 2 apartment complexes with pools, and both of them were closed until just about 2 weeks ago. One in Alameda County, one in Contra Costa County. Public pools were part of the next phase for reopening in both of those counties. So we got kids and adults swimming now. And as you know, pools, I call both of the pools a $1 million pool to the owner, because I believe that the owner is getting $50 a month more in rent because of the gorgeous pool in the center of the complex, and because he's owned both of the apartment complexes for 40 years, it translates to $1 million in rent for each of them. So I call them the $1 million pools, but they are also such a liability. Well, I know a lot of apartment owners are filling in their pools just because of the liability of an accident in the pools, but both of ours are open.
When you said the $1 million pool, I thought immediately lawsuit. Chuck maybe had the same thought. Okay,
I did rent.
Here's
The
another
correct answer
question.
is that certain of the community shelter-in-place orders did not allow public pools to be open. And as Mr. Connolly indicated, those are being eased up at this point in time.
Right, it really depends county to county, and I mean, just there's so much variation there. You have to check your local resources there. The tenant. Okay, here's another question. The tenant didn't pay from March, April, or May rent because of declared COVID-19 hardship. The tenant didn't show any proof of hardship. Tenant has now moved out without 30 days notice. Can the owner put those months of back rent as a reported debt against the tenant credit report with AOA's debt reporting service? Okay, let's see. That's kind of related to me. With the debt reporting service, the way that it is right now, because it's been declared as a COVID hardship, we have to be extremely careful with that. And so I would say definitely you may not report that today. And I think once the dust settles, we may be in, everything is lifted and that's still there at that point, we would be able to do that. But yeah, the reporting, it can only be from what happened pre-COVID-19. And right now it's just a freeze on everything that's happened during that. And Chuck, either of you guys have any other thoughts on that? If it wasn't our service, any kind of other action that people would want to take with COVID-19, with someone in this case where they didn't show any proof, they didn't go through the right processes?
I think even if they showed proof, it's still a debt that is owed. If it became due and owing during the COVID-19 moratorium, though, I would not put it as an issue against credit until the deadline for them to pay that has passed.
Exactly. Great. How long will it take until we get our property back from deadbeat renters? Here's someone who's been burned. And what do you think, Chuck?
I wish I was as upbeat as Mr. Connolly. I think it's going to be a while before you're going to be able to get into court. Tenants have a right to force a jury trial in eviction, and that's really the only hammer that you have to get your property back. And it's going to be a while.
Right.
Mike,
what about you?
What that is going to be, because it's a fluid situation.
Great. Mike, what's your guess?
There are a certain percentage of tenants that are not savvy with the tenant laws that are in place right now with this virus. And I had one particular group of tenants that refused to pay their rent. I had the hardest time getting them to fill out the COVID-19 income, the fact that their income was affected by COVID-19, to fill out the paperwork. Took me several weeks just to get that back from them. And in communicating with the owner of the property, what we decided to do was send a notice to the tenants stating that you have 60 days to vacate. The owner is moving back into the home, and they're vacating. So there are a certain percentage of tenants that aren't aware of how far they can push the limits with COVID-19, and so while that's kind of a gray area, the tenants are vacating. So, do you have anything?
I got to say that you have to be very, very careful in that. I understand, sometimes you can have a contract provision that may not be enforceable. People know it's in a contract, so they apply by it. But in jurisdictions like Alameda, there are tenant lawyers that specialize in this. If somebody moves out based upon a notice that should not have been provided, the owner can be liable for a wrongful eviction. So that is something that I would say please tread lightly on. If it's not legal, I wouldn't do it. It's just to be careful there. Okay.
Here's the question, Chuck. If the owner does move back in, is it an illegal eviction?
Oh, no. If you have a good reason for the owner to move back in and you follow the procedures, there's a owner move in. It's not an LSAC, but it's an owner move in. It's a just cause for eviction. It's issued in good faith, and the person is going to stay there. They're going to move in within 3 months, and they're going to stay there for the full 3 years. Then that's absolutely in good faith, and you can absolutely do that. What I was hearing is that they weren't savvy with the laws, and that raised a red flag with me. But yeah, a valid move-in, absolutely, you can do that, and you're going to have to pay relocation benefits.
Right. Yeah, and every county is different, right?
Yes.
So here we are, the next question, and this is a good one. Is it still advisable to serve a rent increase as long as you add on the document, do not pay this amount until further notice? Here's one way that people are trying to get the rent increase so that it falls at the same time every year, and they stay in compliance with the rent control.
Well, I personally like that. I like that clause because in my presentation, you'll see a rent increase is justified, but yet you don't want to present it during this time. So to put that clause in the rent increase makes sense to me.
I think that is absolutely okay. Again, it goes county to county, city to city. Certain legislation says that if you are entitled to a rent increase, this will not prevent you from getting that standard rent increase, even if you don't collect it. Certain legislation says you cannot issue a notice of rent increase, so that it has to be case by case to do that. But as long as you're saying, and it's clear that they don't have to pay it now, I think you're protected. Mm-hmm. And it's a good idea. Yeah.
And what is the current amount that they actually can raise the rent?
Well, that's jurisdiction dependent. So if you're exempt from local rent control, you can raise it, 5% plus cost of living under the new law. And then if it's more than that, you're going to have to give a certain amount of notice. If you're subject to rent control, it'll depend upon that jurisdiction's amount. I believe Oakland is going to fix it this year at 3.5%.
Anyone know
Again, it's jurisdiction dependent.
Anyone know what the CPI is for those that are not under local rent control, but just under the state rent control? It's 5% plus.
It's 2 to 3%. It's been typically the annual CPI.
And there's a cap of 10%. So if your CPI was 6% and you added your 5, you couldn't just set forth 11%, but up to 10% on non-rent controlled properties.
Okay, can we raise the rent and then give a good tenant a discount if they pay their rent on time? As a reward to tenants we really don't want to raise the rent on, but keep the official rate higher.
The answer is yes, and I think that's a good idea. If you need to raise the rent so that you don't fall behind, especially in rent controlled jurisdictions, so you don't fall behind what you can rent, you have to and provide them with some concession. Good idea.
I like that. Yeah. You're making a concession, I think it's a strategy.
All right. I think we're having a little problem with connection right now. Can anyone hear me?
I can hear you.
Yep.
Okay, there we are. Well, we had a little glitch there with the internet connection, it seems like. Can you start from the beginning there?
I think this was the question about whether or not you can give a rent increase combined with a concession.
Right.
And if that is the question, then I think the answer is yes, you can. I actually think that it's a good idea because you're locking in at least what the base rent will be going forward, and you don't suffer a decrease in that. And then you have more control over what you're going to charge. If you were willing to give a concession, that's great, but you don't have to, right?
Mm-hmm. Okay, Mike, I have a question for you, and this is a really good one. Everybody wants to be compliant. What type of signage do you need to post at your apartment building? This person has a 14 unit specifically, but for any rental, is what signage needs to be up? That's COVID related.
It's COVID related. Oh boy, I have not put up any signage with any COVID related signage on any of my properties. I do not know if it's required. I just simply know at my open houses that I require shoes off, masks on, don't touch anything, one party at a time. Chuck, do you have anything to add to that?
Yes, I know in Alameda County and several of the other counties in the Bay Area, their shelter in place were very similar. There were some differences, but they sort of went lockstep in the shelter in place. And there are signs that are required for buildings. I was just trying to look. If I can find one, I'll pop it up. There's actually a recommended form for the city, in Alameda County that they want you to use. And it basically says, hey, there's COVID-19. You got to wear a face mask. You got to stay 6 feet apart. And it needs to be in a prominent location so that people see it when they're walking in. And there are mask and distancing requirements for residential properties, especially those with 14 or more. Mm-hmm. So if I can find it, I'll put it up and share the screen.
Yeah, I think Cal OSHA is a great resource as well. If you have a public facility, it seems like following their general guidelines would be a good idea. Okay, here's the question. Can you discuss cash for keys or tenant buyout agreement under rent control?
Okay, so did you want to answer that, Mike, or do you want me to answer that?
I'm going to defer to you.
Okay, so cash for keys, depending upon the jurisdiction, is really not allowed anymore. If you're not in a jurisdiction that governs what they're now calling move-out agreements, which is the cash for keys, you can do it. So Contra Costa, excluding Richmond and maybe Antioch now, you can still do it. You can buy somebody out, not a problem. It's a good idea. They get a little money to move. You're not required to pay a certain amount. You get your property back. People have thought that landlords were taking advantage of that, and people had to sign these buyout agreements. So places like Oakland, Berkeley, San Francisco have their own agreements, and I can tell you they're pretty onerous. The floor is the amount that you would pay for relocation. You have to advise the rent board that you're going to enter into negotiations with your tenant, and you need to do so before you start negotiating with the tenant. And then when you actually give an agreement, it has to be in writing. They have a certain amount of time that they're allowed to get out of it. Sometimes it's 45 days. It can be as little as 15 days. If they move out, it's then irrevocable, but you have to advise them that it's not required. They can see an attorney. There's a form that you can use. And once that's done, you then have to file that form with the rent board, so they keep track of who did the buyout, when and where, and how much was paid. Cash for keys can work only in jurisdictions that do not cover the move-out agreements.
Sounds like you kind of covered this a little bit. Can you sell your rental units during COVID-19 if a tenant lives in one of them?
Absolutely. There's no restriction on the sale of your property other than being able to get it sold at a price that you want. You may not be able to remove the tenant and all those other issues, but you want to sell your property with a tenant in it, no restrictions other than how you show it.
Okay, great. I have someone, a question from Oakland, and they say, they're right, with all of these issues, do you think we may have to set up ourselves financially if possible? It seems it may take up to a year or longer to get paid. And so, Mike, yeah, what would you say?
Yeah, well, every apartment owner either theoretically or in reality should have reserves set up, but nothing has really prepared us for month after month of not being paid. So, most of my tenants are IT workers still getting paid, working out of their apartments, their homes. Mm-hmm. So, very, very few have been affected, but to the point where they're not paying. But I just, as a fellow landlord, I own commercial property in the Central Valley, not apartments, but they have not been occupied. So I have across the board given a 33% discount in the rent for the last 4 months to all my commercial tenants, and allowed them to take the 2/3 that is due to amortize that over 12 months. So it's something I did not budget for, but these are extraordinary times.
Okay, I have already obtained an unlawful detainer in early March, but allowed the tenant to stay till May 15th without rent. But he is now refusing to leave. He was never working, but on a pension, so COVID has nothing to do with his tenant's issue. What would the remedy be?
Okay, so that's somewhat of a loaded question. When you say that you had an unlawful detainer, I would need to know whether you actually have an unlawful detainer judgment, and then what the terms were that you allowed somebody to stay. If you allowed somebody to stay in the unit and pay you rent after you obtained unlawful detainer, I can tell you that there will be an argument that you waived the unlawful detainer and they're okay there. The second aspect is, let's assume everything's fine. You got your unlawful detainer. He or she was staying there. It's non-COVID related. I had similar situations where it has nothing to do with COVID-19. Should you be able to get into court and get them out pursuant to the eviction? The answer is yes. Right now, you're going to have great difficulty getting into court and getting relief because the sheriff, not only the courts, but the sheriffs have been instructed not to execute any writs of possession. And that's what you would be looking for your unlawful detainer. I'd be very concerned about potential waiver if you're looking for rent after you obtained it. So that would be, you'd want to speak to somebody about that.
Here's one. My tenant told me that he got coronavirus, so he is not going to pay the rent. He has not paid any rent since April. So can I ask him for proof? What can I do now? This is in Santa Clara, Saratoga.
You can absolutely ask for proof, and it's in the local ordinance down in Santa Clara, where in Santa Clara they're required to provide you. I don't remember the exact time frame, but you make a demand for the proof. It was part of the presentation there. If you want it, we can send it. There's documents that you can take. They can give you a declaration. They can tell you that they're out. They can send you pay stubs. You can ask for that documentation. And I believe in Santa Clara, they're required to provide you with that documentation. And then if you don't get it in Santa Clara, you can say, hey, this is evidence that it's not related to COVID-19 because they're not providing it to me. I can tell you in Solano County, really quickly, they presume that non-payment is due to COVID-19, and it's the burden of the landlord in an unlawful detainer to prove that it wasn't COVID-19 related. So again, the local jurisdictions vary.
And if that document's not provided, Chuck, then you are able to post a 3-day notice?
That's what I would recommend. And in that 3-day notice, you would indicate, we asked for the documentation. You were required to provide it by X date. You didn't. Therefore, we believe that this is not COVID-19 related, and we're not subject to the moratoriums.
All right, Mike, here's a question.
We'll have to get into court.
Here's one. My tenant has paid partial rent for the month of June. She still owes $900. Do I need to send her a statement indicating that she still owes the balance? And should I set up a payment plan?
Okay.
Loaded question there.
Yeah. I would say absolutely you send them a statement that that they still have the balance remaining. And a payment plan, again, as I mentioned in my presentation, we don't want tenants to fall behind more than just a few weeks. If they start rolling a balance from the previous month into the next month, the chances of recovering it are practically zero. So one interesting thing that we did, all of my owners saying that most likely they're not going to have an issue with the resident. However, in this business, we definitely have some real hard luck stories. And I'm asking that you put together, that you send a contribution. We're going to set up a fund. Whatever you contribute, we're going to match. We actually call it the Shelter in Grace Fund. It's on our website. And we had over $5,000 contributed by our owners to this fund, which we're matching. And it allows me to hear a hard luck story and make a concession with that particular tenant that is beyond the $100 or $200 discount that I've been giving. For instance, I had an airline attendant that was renting a 1-bedroom condo, and it was a out-of-country airlines. She was furloughed. Actually, they closed their U.S. bases. She not only was out of a job, but she was getting no unemployment because it's a foreign airline. So here she was, with just no resources. So we were able to basically cut her rent in half, and we're taking it month by month. But again, just taking these measures during these times.
Great, thank you. Here's one. How do I protect my property from a bad tenant damaging it since I cannot evict them for any reason? The tenant are not respecting the property. They've moved in a pet and are doing drugs, and I have no recourse. What would you suggest?
Those may be health and safety. So if they're smoking legal marijuana and they're not supposed to be smoking in the unit, probably not going to get much traction here in the Bay Area. If they got a meth lab, or they're selling drugs or doing something illegal, that's nuisance. That's health and safety type issues, and those are allowed to go forward if you can get into court. If they're damaging the property, I also categorize that as health and safety. So it's worth trying to get into court. I don't think that you're categorically locked out right now, because at least the language of the law says no evictions except for health and safety. And I would think damage to property, drugs, and whatnot would be a health and safety issue that at least would get you in front of court.
And that was that tenant presented himself in a much different way when he first rented that property. That is why the credit score is absolutely crucial. I can guarantee